On January 30th, 2026, the United States Department of Justice released over 3 million pages of documents, 180,000 images, and 2,000 videos related to the Jeffrey Epstein investigation. This marked the largest disclosure under the Epstein Files Transparency Act, legislation passed with overwhelming bipartisan support in November 2025. The release provides documented evidence of how legal, media, and social networks responded to early investigative reporting between 2010 and 2011. The files reveal a structural pattern: aggressive legal intimidation, public relations coordination, and institutional caution that limited accountability for over a decade. This analysis examines what these documents demonstrate about the mechanisms that delayed transparency, the role of early investigative journalism, and the institutional factors that shaped outcomes. The roadmap is straightforward. First, the verified timeline of events from 2010 through 2026. Second, the documented responses to early reporting by the Daily Beast. Third, the institutional dynamics revealed in internal communications. Fourth, the analysis of how legal and social networks function to limit exposure. Finally, 3 plausible scenarios for what additional unreleased materials might reveal about prosecutorial decision-making. Between March and July 2010, the Daily Beast published a series of investigative articles by reporter Conchita Sarnoff that documented multiple allegations against Jeffrey Epstein. The reporting detailed a 2007 non-prosecution agreement in which Epstein avoided a 60-count federal indictment and instead served 13 months in county detention on state-level prostitution charges. Court documents cited by Sarnoff included affidavits from multiple individuals describing a recruitment system that operated over several years. Flight logs showing high-profile passengers on Epstein's aircraft were published. The articles named French modeling agent Jean-Luc Brunel as a key figure in the network. All of this information was publicly available by mid-2010, more than 8 years before Epstein's 2019 arrest. The newly released files contain internal communications showing how Epstein and his associates reacted to the Daily Beast's reporting. Emails between Epstein and publicist Peggy Siegel discuss strategies to neutralize coverage. Epstein sent messages to real estate developer Mort Zuckerman, requesting intervention with the Daily Beast's founder, Tina Brown. A 3-page letter from attorney Jay Lefkowitz of Kirkland & Ellis was sent directly to Brown in 2010, threatening defamation litigation. The letter challenged characterizations in the Daily Beast's reporting and claimed the articles were sensationalized. Despite these threats, no lawsuit was filed. Internal emails show Epstein compiled a list of statements he considered libelous, but legal action was never pursued. Additional documents reveal communication between Epstein's team and media contacts. Siegel, who organized social events and had professional relationships across New York's media landscape, provided updates to Epstein about newsroom activities. She had previously invited Brown to a dinner that would have included Epstein, Prince Andrew, and filmmaker Woody Allen. Brown declined after learning the guest list, stating in the newly released files that she referred to it as the pedophiles' ball within her newsroom. Siegel's emails to Epstein indicate she continued to provide information about the Daily Beast's editorial direction and personnel. One document in the release shows communication within the U.S. Attorney's Office for the Southern District of Florida. Prior to the Daily Beast's publication, Sarnoff sent a detailed 16-question request for comment to federal prosecutors. Internal emails between assistant U.S. attorneys discussed the inquiry. One unnamed prosecutor wrote to another, "Stuff pending on this, so we can just take the easy way out." The response was, "Our position is the investigation is still open and pending." When questioned further about what remained pending, the exchange ends without explanation. A 2020 Department of Justice review found that former U.S. Attorney Alex Acosta exercised poor judgment in the 2007 non-prosecution agreement, but did not find professional misconduct. The files also document continued social engagement with Epstein after the Daily Beast's series was published. Emails show that multiple individuals continued correspondence and accepted invitations despite the public reporting. One email from businessman Howard Lutnick references plans to visit Epstein's Caribbean property with family members. This occurred after the 2010 reporting had documented the allegations in detail. The documented pattern suggests that social networks did not immediately isolate Epstein following media exposure. Several individuals later stated they were unaware of the full scope of allegations, but internet search results would have surfaced the Daily Beast articles immediately. This leads to the analysis of structural mechanisms. The first factor is legal resource asymmetry. High-profile law firms were retained to issue threat letters to media organizations. These letters carried implicit costs: potential litigation, time-intensive legal review, and reputational risk. For smaller or independent outlets, such threats could deter coverage even when reporting was factually supported. The Daily Beast proceeded with publication because its editorial team, led by Brown and executive editor Edward Felsenthal, had conducted extensive verification. Multiple levels of editorial review were applied specifically because legal action was anticipated. Not all newsrooms had equivalent resources to withstand prolonged legal pressure. The second factor is social network dynamics. Epstein cultivated relationships across finance, academia, politics, and media. Individuals connected to him were themselves embedded in overlapping professional and social circles. The files reveal a favor-bank system in which access, introductions, and logistical support were exchanged. Some sought financial advice or investment opportunities. Others valued access to Epstein's social network for professional advancement or philanthropic connections. Still others used his private aircraft for convenience. The common thread was that these relationships created reluctance to publicly disengage, even after damaging information became available. Disengagement carried social and professional costs within elite networks. The third factor involves prosecutorial decision-making. The 2007 non-prosecution agreement has been extensively analyzed. Federal prosecutors drafted a 60-count indictment alleging conspiracy to procure individuals under 18 for commercial sex acts between 2001 and 2005. The indictment named Epstein and 3 unidentified co-defendants. Instead of proceeding with federal charges, prosecutors reached an agreement allowing Epstein to plead guilty to 2 state-level prostitution charges. He served 13 months in county detention with work release privileges. The newly released documents show internal discussions about media inquiries, but do not fully explain the decision calculus that led to the agreement. Approximately 3 million pages remain unpublished, and it is unclear whether those files contain additional internal deliberations. The fourth factor is timing and media environment. The Daily Beast Zest 2010 reporting occurred before the Me Too movement and before renewed attention to sexual misconduct by powerful individuals. Public discourse about allegations against high-profile figures was different. Victims were often questioned about their credibility and motivations. Legal defenses frequently emphasized consent or claimed that individuals were aware of the nature of arrangements. The newly released Lefkowitz letter to Brown includes language suggesting that individuals involved were not innocent and were engaged in transactional relationships. This framing was more common in 2010 than it would be after 2017. The fifth factor involves institutional caution. Media organizations face legal, financial, and reputational risks when publishing investigative material about powerful individuals. Editors must weigh public interest against potential litigation costs, advertiser pressure, and access to sources. Some organizations declined to pursue the story when offered. Conchita Sarnoff reportedly approached multiple outlets before bringing the material to the Daily Beast. Brown's publication had institutional backing from Barry Diller, whose company IAC owned the Daily Beast. When Epstein's legal team attempted to pressure IAC leadership, Diller did not intervene to stop publication. Not all media organizations had ownership structures that provided equivalent editorial independence. These dynamics created a structural environment in which exposure required sustained effort across multiple domains: investigative reporting that could withstand legal scrutiny, editorial leadership willing to proceed despite threats, ownership that did not capitulate to pressure, and timing that aligned with broader public attention to the issue. The Daily Beast's reporting met these conditions, but did not immediately trigger criminal prosecution or widespread social isolation of Epstein. Significant enforcement action did not occur until 2019, following additional reporting by Julie Brown at the Miami Herald and renewed federal investigation by the Southern District of New York. The newly released documents also reveal the scope of Epstein's information gathering. He maintained correspondence with academics, policymakers, and business leaders. Emails show exchanges about geopolitical topics, economic policy, and scientific research. These communications served multiple functions: establishing credibility, maintaining access, and gathering information that could be valuable in financial or strategic contexts. The files include emails between Epstein and economist Lawrence Summers discussing political topics during the 2016 and 2017 period. The content of these exchanges is mundane, but they illustrate sustained communication networks even after Epstein's 2008 conviction. Another category of documents involves victim statements and police reports. These materials were used in the original investigations and contain detailed accounts of recruitment methods, promises made, and exploitation experienced. The January 30th release drew immediate criticism from victim advocates because at least 31 individuals who were victimized as minors were not properly redacted. Names and identifying details were visible in documents that were supposed to protect privacy. The Department of Justice acknowledged the error and stated that review processes involved over 500 attorneys working to balance transparency requirements with privacy protections. Several foreign governments announced investigations after reviewing the files. On February 3, 2026, Turkish prosecutors opened an inquiry into allegations that Epstein trafficked Turkish minors. The review was triggered by references in the documents suggesting individuals were transported from Turkey, the Czech Republic, and other locations. Lithuanian prosecutors also announced an investigation, after media reports indicated that names of Lithuanian nationals appeared in the files. These developments demonstrate that the scope of the network extended beyond United States borders and involved multiple jurisdictions. The scenario analysis addresses what remains unknown. The Department of Justice has stated that the January 30th release fulfills its obligations under the Transparency Act. However, Deputy Attorney General Todd Blanche acknowledged that approximately 6 million pages were identified as potentially responsive to the law. The department released 3.5 million pages and stated that remaining materials were either duplicates, unrelated to the case, or subject to ongoing grand jury secrecy protections. A federal judge ruled in August 2025 that approximately 70 pages of grand jury materials must remain sealed. Congressional members, including Representatives Ro Khanna and Thomas Massie, have requested access to unredacted files to assess whether the department complied fully with the law. Scenario A is that no additional significant information exists beyond what has been released. The remaining materials consist of duplicate documents, administrative records, and items genuinely unrelated to the core allegations. In this scenario, the 2007 prosecutorial decision was the result of standard plea negotiation dynamics, concerns about witness credibility, evidentiary challenges, and resource allocation. The easy way out comment in the internal email was simply a colloquial reference to standard responses to media inquiries rather than evidence of improper influence. This scenario is plausible if the review process was thorough and if prosecutorial decisions were made within normal discretionary parameters. Scenario B is that additional documents reveal institutional pressure or influence that shaped the 2007 agreement. Epstein's social network included individuals with connections to law enforcement, prosecutors, and policymakers. If communications exist showing external pressure, attempts to influence charging decisions, or coordination between Epstein's legal team and prosecutors beyond standard defense advocacy, those materials could explain the favorable outcome he received. The easy way out comment might be part of a broader pattern of institutional reluctance to pursue aggressive prosecution. This scenario is plausible given the unusual nature of the non-prosecution agreement and the documented connections Epstein maintained across institutional domains. Scenario C is that unreleased materials contain information about additional individuals whose involvement has not been publicly confirmed. The draft indictment referenced 3 unnamed co-defendants. Ghislaine Maxwell was convicted in 2021 for her role in recruitment and facilitation, but the other individuals remain unidentified. Documents could reveal coordination among multiple actors, financial arrangements, or international dimensions of the network. This scenario would explain why certain materials remain sealed, and why congressional oversight continues despite the department's claim that transparency obligations have been met. What remains clear is that the newly released files document a sustained effort to manage media coverage, pressure journalists, and navigate institutional accountability. The Daily Beast's reporting in 2010 provided detailed documentation of allegations, but legal, social, and institutional mechanisms limited the immediate consequences. Epstein continued to maintain elite connections, conduct business, and move through social networks for nearly a decade after that reporting was published. Enforcement action only occurred after additional investigative reporting, after cultural shifts made allegations more credible in public discourse, and after a new prosecutorial team in the Southern District of New York reopened the case. The documents also demonstrate that investigative journalism faced significant obstacles. Legal threats required editorial teams to conduct extensive verification. Publicists and social intermediaries worked to undermine reporters and pressure editors. Institutional connections were leveraged to request intervention from media ownership. These tactics did not succeed in stopping the Daily Beast, but they illustrate the resources available to powerful individuals seeking to limit exposure. In cases where editorial leadership was less resolute or where legal resources were more limited, such pressure could deter coverage. The summary is this. The Epstein files released in January 2026 provide documentary evidence of the institutional dynamics that shaped accountability between 2010 and 2019. Early investigative reporting by the Daily Beast detailed allegations, documented court records, and published flight logs showing elite connections. Legal threats were issued, but litigation was never pursued. Social networks continued engaging with Epstein despite public reporting. Internal prosecutorial communications suggest institutional caution about pursuing media inquiries aggressively. Cultural factors in 2010 made allegations less likely to trigger immediate social or professional consequences. The combination of legal intimidation, social network protection, prosecutorial discretion, and timing created an environment in which transparency did not immediately produce accountability. Significant enforcement action required additional reporting, cultural shifts, and renewed prosecutorial focus nearly a decade later. Approximately 3 million pages remain unpublished, and congressional oversight continues. Whether those materials contain evidence of improper influence, additional coordination, or previously unidentified participants remains uncertain. What is documented is a structural pattern in which wealth, legal resources, social networks, and institutional caution created significant barriers to accountability. Investigative journalism eventually contributed to criminal prosecution, but the timeline demonstrates how multiple factors must align for transparency to produce enforcement.